Hello, my name is Steve Lewicki, and I'm a partner at Lewicki O'Connor Hunt & Miser, a full-service law firm in Howard County, Maryland. In Maryland, a mechanics lien statute gives contractors and subcontractors a powerful tool to obtain payment for materials and services. A mechanics lien is a means by which a person or company that provides labor or materials on a construction project can place a lien against improved real property for the value of the unpaid labor and materials, but only if the requirements of the mechanics lien statute are strictly adhered to. Maryland's mechanics lien statute is complicated, and there are some important aspects of this legal remedy that contractors and subcontractors should always keep in mind. Any person or company that furnishes work or materials to a construction project under a contract potentially may establish a mechanics lien. Contractors, subcontractors, and suppliers all can claim such a lien, regardless of whether they have a direct contract with the owner of the property, as long as the particular labor was performed for or about the subject building, and as long as the particular materials were for the subject building project. A mechanics lien is only available for certain types of construction projects, however. Newly constructed buildings are subject to mechanics liens, though what exactly constitutes a building is sometimes an issue because not every type of structure on land constitutes a building for these purposes. For construction projects that involve repair or renovation of existing buildings, a mechanics lien is only available if the project involves the repair, rebuilding, or improvement of the building to the extent of 15% of its value or more. Condominium units and the common elements of condominiums are also subject to mechanics liens, but special notice requirements apply in the case of condominiums. A very important aspect of Maryland's mechanics lien statute is a requirement to give written notice of an intention to seek a lien in some circumstances, and strict time requirements apply to giving that notice and bringing suit. Anyone seeking a mechanics lien who does not have a direct contractual relationship with the property owner, for example, subcontractors and in many cases suppliers, must comply with notice requirements set forth in the mechanics lien statute. When this type of notice is required, it must be mailed by the lien claimant to the property owner within 120 days after the claimant performed the work or furnished the materials. There are a lot of nuances regarding when this 120-day period begins to run, and many court cases address this issue. Separate and apart from giving the required notice of an intention to claim a mechanics lien, the actual petition to establish a mechanics lien has to be filed with the appropriate circuit court no later than 180 days after the work has been finished or the materials furnished. The correct parties must be named as defendants in that suit, and there are detailed requirements for what must be included in the petition that is filed with the court. After a petition is filed with the court, there's a two-step process by which the court first reviews the papers that have been filed and holds an initial show cause proceeding to determine if there is sufficient cause to establish an interim mechanics lien. The court typically will set a bond for entry of an interim lien. If an interim lien is established, then in the second stage, the court will hold a trial on the merits of whether the mechanics lien should continue thereafter until satisfied. At any time after a petition to establish a mechanics lien is filed, the property owner can file a petition to have the property released from the lien upon the filing of a bond sufficient to protect the lien claimant. Once the lien is established, the lien claimant then has 1 year to file a petition to enforce the lien. Mechanics lien can be a very powerful means for contractors, subcontractors, and suppliers to ensure payment, but they're really complicated. The Maryland mechanics lien statute differs from those in other states. If you're a contractor, subcontractor, or supplier seeking payment for labor and materials provided in Maryland, or if you're a Maryland property owner that has received notice that someone intends to assert a mechanics lien against your property, or has already petitioned the court for a mechanics lien, I encourage you to promptly consult with an attorney that's knowledgeable about this area of the law. Very strict time limitations apply to these claims. Our firm has the depth of experience to provide detailed guidance regarding Maryland mechanics liens, the Maryland Trust Fund Statute, the Maryland Prompt Payment Act, and the Maryland Little Miller Act.